Most just compensation debates focus on the value of real estate and damages to the remainder. However, it is possible to get just compensation on different aspects, particularly for businesses. These include things like fixtures, the cost to avoid business disruption, and potentially the going concern value of a business if the relocation of the business is not practical for some reason. We're going to go to 3 different locations where the Michigan courts upheld property owners receiving payment of the going concern value of their business. We're just north of Grand Rapids, actually just south of the Grand Rapids Whitecaps ball field. At one point, there was a different entertainment venue in this general vicinity, the Grand Rapids Speedrome, which was a local racetrack. It was condemned and acquired to build 131, which is behind me. As part of that condemnation, the tenancy of L&L Concessions, who had the exclusive right to sell food, drinks, and other sundries at the racetrack, was terminated. The question was, what type of business damages could be paid as a result of that taking? Generally, the going concern value of a business is not compensable. However, the Michigan Court of Appeals reviewed other situations in which that type of just compensation was paid. For example, there was a fisherman whose business was taken by the federal government when his fishing territory was expanded for a military base and he lost the concession granted by the state. There was a bar in Minnesota in which it was unable to relocate its liquor license within the jurisdiction, ending its business. And there was a laundry in World War II that was acquired by the federal government to use as a laundry temporarily to clean clothes at an army base. Obviously, a concession that operates exclusively in a racetrack is dependent upon the existence of the racetrack for it to exist as a business. And the Court of Appeals ruled that there may be cases when the loss of a particular location may destroy business altogether for want of access to any other that is suitable to it. Whatever damage is suffered must be compensated. As a result, L&L Concessions was able to recover the going concern value of its business. Now, let's go to Lansing, where that concept was expanded to cover a unique hamburger stand. We're in Lansing, where the Kewpie Burger hamburger stand used to be. This is another example in which the Court of Appeals allowed a business to obtain going concern value as just compensation. But it's a different scenario. It's not a tenant who's dependent upon the existence of its landlord. It's not a fisherman with no other place to relocate, or a bar in a municipality with no other locations that would allow transfer of its liquor license. It's a hamburger stand. But the Court of Appeals determined that it was a unique business with some kind of a unique product that was dependent upon its location. And because of the dependency upon its location, it was allowed to obtain just compensation for the loss of going concern. Next, we'll go to the city of Detroit, where there's another example in which the Court of Appeals allowed going concern value. We're on the west side of Metro Airport in Romulus. In 1997, as part of a 550-acre acquisition for an expansion, the Michigan Supreme Court decided a case called Wayne County versus Britton Trust. The Britton Trust owned a building and operated industrial businesses out of it. The question raised was, what constitutes a fixture and how is just compensation determined for those fixtures? For the first point, the Supreme Court recognized that obviously something physically affixed to the land constituted a fixture. However, it adopted a more broad view. For example, it included the concept of constructive annexation. Essentially, objects that were used in conjunction with a business and in conjunction with fixtures also constituted fixtures. For example, if a machine was affixed to the land, the tooling, which was not affixed to the land, would constitute a fixture. The next question involved, how is just compensation determined? The Supreme Court recognized that property owners have two choices. First, they can take what's called value in place and obtain the value of the fixtures as part of the real estate. Alternatively, property owners could elect what's called detach reattach. Under detach reattach, the cost to physically detach the fixtures, move them to the new location, and reattach them is collected by the property owner. However, to the extent that the detachment of the fixtures reduces the value of the real estate, that is also taken into account. Finally, the Supreme Court recognized that property owners are paid relocation costs for non-fixtures. The three cases demonstrate an expansion in the ability to obtain going concern value. The racetrack concession stand was obviously a situation in which that business was destroyed and unable to be relocated because it was physically within a business acquired under eminent domain. The hamburger stand case, a use which is common throughout the community, focused on unique attributes of that particular case and also discussed the inability of that business to relocate. Finally, the drugstore case recognized that the taking of other properties in the vicinity of the particular business for part of the project could trigger the ability to be paid going concern value. It's necessary to balance these types of issues to find the right path forward to maximize a property owner's just compensation.